He's inhaling it. You can actually see him on the video inhaling it. The officer tells him to stop. The officer, even if the officer's incorrect as to what it is, while the officer's investigating that, the officer is giving a lawful command so that he can fulfill his obligation to investigate what's going on. Officer Gonzalez arrives. What is then further clear is that they get him up. He then charges Officer Gonzalez. They have to take him down and they have to tase him. I don't know under what argument, while an officer's even just minimally investigating the potential of a crime, that officer could be charged and physical contact made with that officer. If you show me some case law that indicates that, then I won't bind over. But you don't have it because that's not the law.
Thank you, Mr. Your Honor, we have not been right next to and look for you and shoot.
What do you mean? What did you say?
No surprise party. Morning, Grant.
Good morning.
Did you do the waiver?
Yes, sir.
Michael Gaddy, Assistant Public Defender, on behalf of the Public Defender's Office, we concur with the prosecution if they've already gone on the record, and we do not believe that any conflict exists. To the extent any does, we would waive such conflicts.
Thank you. The court, for its part, also does not believe there's a conflict either in the Michigan court rules, so the case is decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. All right, gotten that part out. Everybody's ready? No?
Oh. Okay. I have no.
So when do I have? 14?
I don't think one
Yeah,
of
for Now we need to go.
Okay. Who do you have? You can have both.
The waiver, we think. Okay. And Ms. Zenda, you ready on anything?
When Mr. Brunel, that one's mine. We'll be ready.
Oh, okay. All right. So you're the one actually working. Cook, what are you doing? Are we ready?
Meeting on a defendant as well as public defenders.
We have no public defenders here. Why is that? Are they all next door?
No, I checked.
They're not next door?
Not seeing public defenders next.
Seriously? What? Yes. Tell them I'm ready to go.
What do you have? Pretty public.
Morning. Good morning, sir. How are you? Pardon? You're in the wrong room. Why? You don't want to see me? No, I'll do something to you if you want me to, but all right, you can go over and see the other judge. That's okay. I'm good. Take care. Is it more next door? Okay. See? You make people operate on my schedule.
Yes.
The only one next door is Mr. Ballinger.
We only have Bellinger next door? He doesn't have anything. Thus, does he? So where are the rest of them?
Not next door. That's so really corroborating. He said when he there, we're going to go next door is the only judgment.
Yes. See if anybody's ready.
No, they've got that's pretty.
Okay, that's 7 or 8 next door. How many in custody do we have? One?
Yes, got it. So, sorry.
Got it.
You just started me. Yeah.
No, Mrs. Enda, the moment you leave the room, I'm gonna call your case. All right. Wow. Yeah. Get something done today.
Yeah.
Where's Ann? I did. But why is that taking so long?
Did you want to do it? But he was awesome. Really?
How can I help you, Your Honor? Mr. Dunaway and Mr. Gandy are still talking to prosecutors. Judge Moore's not on the bench yet, though.
So Judge Moore's not on the bench. I'm on the bench. They're next door talking. All right. I would bet if I started issuing bench warrants, they'd get over here. You think? One light. Take care of Mr. Cook. He's been here ready to go. You can come on in. Nothing's going. Yeah, I don't know what they're doing.
Yeah. Yes, we do.
I have more officers than I do attorneys. Hello, Ms. Gaines. Are any of your people ready?
Started 15 minutes ago. Yeah.
Good morning.
So, Your Honor, my understanding is that Mr. Cook is ready on Reed with Ms. Gaines' case, if Ms. Gaines is ready.
Reed? Are you ready on Reed, Ms. Gaines?
Super prosecutor, Your Honor.
Sure.
Can you get my email yesterday?
Oh, they'll be ready. That's pretty good.
No, they're not. It's for a question or an adjournment for the table. His client is gonna be a thing. Assaulting officer.
Looks okay. There are prosecutors everywhere. I have no defense attorneys.
You got it.
Well, no, I could do with less prosecutors, especially since Kennedy walked in. Yeah.
Here comes Mr. Friedel. Friedel, why is it?
We'll talk to you. Burdell, you ready?
Yes, Judge, I'm ready to go.
He is in custody.
We're ready. Yes.
But thank you for that. Yeah. I was at it. I came straight from my house. So that's my first bit of wisdom for the afternoon.
Yeah.
Wow, the students.
Oh.
Who? Where is she? I did. I don't believe it.
Because somehow.
Court does call the cases of the people versus Joshua Hillsborough. Berg.
Kelly's not.
Kyle Brill on behalf of Mr. Hillsberg, who's approaching the podium and will be standing to my right. Your Honor, today is the date and time set for preliminary exam. It's my understanding that people are prepared to proceed.
That's correct.
Your Honor, at this time, then the defendant will be waiving his right to preliminary exam. We have a signed and executed preliminary examination waiver form to tender to the court.
Is that correct, sir?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed?
I do.
You understand that by waiving that proceeding, you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right. People also waive their right. Preliminary examination having been waived, defendant found over on all felony counts, and I think in 0403, that'd be count 1 with 2 following. And on the other matter, will be on count 1 and 2 with count 3. Mr. Burdell.
Your Honor, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pre-trial in these matters will be set for
June 30th at 1:30 with Judge Conlon.
June 30th, 2026, 1:30.
Thank you, Judge. And if we maybe heard as to a preliminary matter, when the court here is deems it appropriate. Mr. Hillsberg, he wants to take the accountable choices while he's in custody, but he needs a court order to do that. We would ask if the court would order him to be made available for accountable choices at this time.
Any response from the people? I will indicate that the defendant is to enroll in accountable choices as part of his bond.
Thank you, Judge.
Thank you.
You're all set. Thanks, Kyle.
Pardon?
You're gonna be first to sign information.
Yes, let me just. Left me up here by myself. No, I'm good. I can do this. She needs to sign off. Court does call the case of the people versus Christian Reed.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Reed. Would you please state your name, sir?
Christian Reed. Thank you.
Stage of separate preliminary examination. At this time, the people are not able to proceed, but I am moving for an adjournment of this matter. I was informed yesterday afternoon that the main witness, the deputy and officer in charge, his wife has entered into labor and so is not available to testify today. I believe that that is good cause and I would be asking for an adjournment.
I did explain to my client that that would likely be found to be good cause, so we are not objecting to the.
Labor would be,
Yes.
okay.
And so we are not objecting to the adjournment, Your Honor.
Well, this gentleman's out of custody, so I mean, I could set it for the 23rd. I just don't, I'm not. Yeah, it's unpredictable. So I will find good cause to adjourn the preliminary examination. I'll adjourn it to my next date after next week, which is actually July 28th.
Okay.
Problem with that? All right.
Right.
So I'll adjourn the preliminary examination to July 28th, 2026, 9 a.m. before me. It's an in-person proceeding. Bond will continue. Thank you, sir.
Thank you.
Right, huh? Video separate.
This would be a photo. He's here, his client is.
For these officers here.
That's.
Well, any other quick. Get that. Court calls case, People State of Michigan versus Kevin Davis.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. James Fifelski appearing with and on behalf of Davis, who's approaching. Come up. Just state your name, please, for Judge Simpson.
Morning, Your Honor. Kevin Ryan Davis.
All right.
Your Honor, this is the date and time separate preliminary examination. I believe we're ready to proceed to an exam.
We are as well, Your Honor.
All right, let's go.
We'll call Officer Anderson.
Sir, please come forward and be sworn.
Right now. He's honestly. Shoot, yeah.
I did.
State, spoken into record.
Nicole Anderson, NAKONAANDERSON.
Thank you. You may be seated. Mr. Cook, you may inquire.
Thank you. Good morning, officer. How are you doing?
Good.
Doing fine. Sir, how are you employed?
Pittsfield Township Police Department nursing.
How long have you been working with Pittsfield Township Police? Any previous law enforcement experience? In what capacity do you work for Pittsfield Township Police? Can you describe what your duties are as a road patrol officer?
Take complaint calls.
Were you working in the same capacity on or about April 6th of 2026? Going to that day, were you working that day? And at any point were you dispatched to 2931 Carpenter Road?
Yes.
Is that here in Washtenaw County? What were you dispatched for?
Male screaming, obscenities, disorder.
Were you with anyone else or was it just yourself?
At the time of arrival, I was by myself.
What did you do when you arrived at that? Or can you describe what's at that location?
It's an abandoned lot. The call came in with a neighbor from a neighboring business, a nail salon. That was a complainant. That the male was located in an abandoned lot next to say.
When you say the male was in the abandoned lot, who is the male? And you sort of gestured a little bit. Can you point to and identify, or do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing? The record may reflect this witness has identified the defendant.
That objection record shall so reflect.
Where did you find the defendant?
Leaned up against, or sitting down on the ground against a 3-foot brick wall. Side of the abandoned lot.
How far was that from the business that you said made the call?
Like 35, 40 yards.
All right. What was the defendant doing when you first saw him?
As I rounded the corner, he was actually puffing what appeared to be nitrous oxide.
What did you do when you saw the defendant?
I told him to stop and put it down. And he continued to,
Did the defendant say anything at that time?
he told me, pardon my French, to fuck off. And I told him to stop, to put it down. Then he told me to suck my dick, or suck his dick.
Did anyone else ever arrive on scene to assist you?
Officer Gonzalez did.
Do you know what Officer Gonzalez's first name is? When did Officer Gonzalez arrive on scene?
Shortly after I made initial contact, as he was argumentative, and so I asked her to step it up, and she arrived very quickly after.
While all of this is happening, what were you wearing at the time?
His exact uniform, the Class B department issued.
And I see there's some patches on the shoulder. Are those your police patches?
Yes.
All right. What were you doing, or what did you do with the defendant at that point?
At what point?
So you said that he made some expletives. What did you do after that?
I asked for my partner, Officer Gonzalez, to step it up due to him being under the influence, what appeared to be nitrous oxide, actively huffing, and his argumentative behavior towards me, dislike for PD or whatever. I asked her to step it up. I attempted to grab the nitrous from his hand. At that point, he turned away from me and kind of tensed up due to his physical nature. I wasn't comfortable doing hands-on with him. My partner.
At any point, did you put hands on the defendant?
Once Officer Gonzalez showed up, yes.
What happened when you put your hands on the defendant? Why? Let me rephrase that question. Why did you put your hands on the defendant?
I attempted to stand him up to take him into custody for humping.
At that point, had the defendant been resisting you physically?
Not physically. Well, I mean, he is tensed up, but
Was he actively fighting back at that point? At any point, did the defendant start to fight back?
yeah, he came to kind of pushed off of us, stood up very aggressively, and then eventually charged Officer Gonzalez.
Said charged Officer Gonzalez.
Other than charging Officer Gonzalez, did he make any other, or did he physically resist in any other way at that point?
Prior to him lunging at Officer Gonzalez.
Oh, so you said he charged, and now you're saying at some point he lunged?
I would describe it pretty much the same, but
Okay.
yeah, he ran towards him.
Did the defendant ever swing at either you or Officer Gonzalez with his fist?
Not at me personally. He did it when he ran at Officer Gonzalez. It appeared to me that he was getting shoved or pushed her.
Did you hear if Officer Gonzalez ever exclaimed anything about being attacked?
She advised that,
Objection, hearsay.
It's an excited utterance, Your Honor.
Overruled. Go ahead.
she advised that she was struck in the face by Mr. Davis.
Did Officer Gonzalez ever exclaim anything about the defendant grabbing her?
Objection, hearsay again, unless it can be contextualized, if it's claimed to be an excited utterance.
Well, I don't, they're engaged with a suspect at that time. What do you mean contextual?
Well, if he's just asking a general question about what she said, we don't know the timing in which she's saying it. If it's not an excited
Is it
utterance.
during the engagement with this defendant that the statement would come? Just, okay. Overruled. Go ahead.
Other than him pushing her while he was still seated on the ground while we were attempting to get him up, she did say out loud, "Stop squeezing my hands," or "Stop."
What did you do after the defendant lunged at Officer Gonzalez?
I took my department issued taser 7 out of my holster. I activated it. Once he made contact with Officer Gonzalez, in an aggressive manner. I deployed my taser.
Was that taser successfully deployed? After you deployed the taser, what happened then?
Mr. Davis fell to the ground. Some verbal orders to roll over onto the stomach and place his hand behind his back, and he did so.
At that point, or following that, was the defendant cooperative?
He's very argumentative. But yes, he was much cooperative actually.
While all of this was happening, did you have a department issued body worn camera? And did that camera capture what happened during this incident? If you saw that footage, would you be able to see it and recognize it? I can, just 1 second here while I get this set up. My apologies.
And
Plugged in, if I can put up my screen for authentication purposes. There we go. Sir, do you recognize what's on the screen right now?
My body worn camera showing the dash of my car.
And this is part of a video, is that correct? Is this video fair and accurate representation of what occurred during this incident?
Yes.
And people move to admit with March People's Proposed Exhibit 1.
the objection are blocked here.
No objection, Your Honor.
Exhibit 1 is admitted.
Thank you. Permission to publish?
Yes.
So 20, for the records, 26 minutes, 34 seconds. I'm not going to play the whole video. I'm going to play just the first few minutes that captures the incident. And I'm beginning from 0.
Okay. So. I have a wall one right there, guy sitting right on the other side of it. And pull up here and he's just screaming. Like blood curdling screams, fuck you, and there's nobody around it. Fuck this shit. It's different. See right in front of. All right, put it down. Oh. Most awesome. Yeah. Blow my license. Hey. What am I doing? You're using Robertson television. I don't know where to stop. You're an idea. Yeah, it's just up there, fine. Yeah, I'm not going to see you.
Gonna pause the video at 3 minutes and 8 seconds there. We can take me off, please. Sir, there was a female officer in that body worn camera. Was that Officer Gonzalez? If I can have just 1 moment, please, Your Honor.
Pass the witness, Your Honor.
Cross-examination.
Officer Anderson, you testified, first of all, this area where you found Mr. Davis was this vacant lot. And that's on the corner of what, Carpenter and Packard?
Yeah, Crystal Packard coming.
If I show you a couple of photos, just to have some still shots of this, would you be able to identify that location? These are A.
Which one's tagged?
I've marked proposed defense exhibits A and B. May I approach the witness, Your Honor?
Where?
Thank you. You recognize what's depicted in those photos, sir? And does that appear to be the front and back area, for lack of a better word, of that brick wall where you found Mr. Davis?
Yeah, the east and west side.
Okay. Your Honor, I'd move for admission just for the location.
No objection.
Exhibits A and B are admitted.
Thank you. Officer, at some point in the video, we see you taking a couple of bags or trying to take away the canister from Mr. Davis. Is that correct? You testified that it appeared to you that the canister he had in his hands was nitrous oxide, right? And at some point you confiscated those items and other belongings and you took photos of those. Is that correct? You got a picture, that'll be C. And as far as evidence of what you were arresting Mr. Davis for, possession of drug paraphernalia, is that what you confiscated these bottles for? Okay, may I approach with exhibit C, proposed exhibit C, Your Honor?
Right.
Thank you.
Just for purposes of the record, is that the photo you took of
the property that you took from Mr. Davis?
Sorry. Almost, but yes.
Okay. Move for admission of exhibit C.
No objection.
See if you admitted.
When you arrived to investigate Mr. Davis, it was what, around 11:30 a.m., somewhere in that ballpark? And as we could see on the video, it was broad daylight out, correct? You estimated the distance from the neighboring business where you spoke to the gentleman that we saw in the video, 35 to 40 yards or so. Is that fair to say? Is it also true to say that when you came upon Mr. Davis, he was alone against that brick wall? And there's nobody out in that vacant lot or on the side in the grassy area there? And didn't anything else on his person, Mr. Davis, such as a weapon or something that would make you think he was a danger to you or anybody else in the area? Did you? Okay. Also, do you know in that, so there's that grassy area, which would be the east side of that vacant lot. Do you know how far that brick wall is from the road itself, that side street?
I'd approximate maybe like 50 foot.
Okay. You would agree it's quite a distance, more than just from here to the court clerks. Okay. And just to be clear, I assume you didn't see anybody in the roadway that was also complaining of Mr. Davis. Okay. When you came upon Mr. Davis, and we saw in the video, it doesn't sound like he is yelling or screaming at that time, right? So he just appeared, as he did on the video, sitting up against the brick wall and essentially minding his own business.
Yeah.
Okay. Again, just to be clear, did you see any sort of no trespass signs or no loitering signs in that particular area? When you came upon Mr. Davis and you saw him inhale from that nitrous oxide canister, did you believe that that was illegal to possess nitrous oxide?
Using that form.
Okay. And that possession of nitrous oxide, or him using it by inhaling it, that was the sole reason you were, I believe, as you said, attempt to stand him up so you could arrest him for huffing, correct? And ultimately, you gave Mr. Davis a citation for possession of drug paraphernalia, nitrous oxide. Is that correct?
I did not.
You did not. If it has N. Anderson on the bottom of that citation, that not be you? Okay. If you take a look at this, may it refresh your memory? May I approach, Your Honor?
Right.
Reviewing that, does that refresh your memory that that was the citation you issued against Mr. Davis? And is the sole charged misdemeanor possession of drug paraphernalia? All right. Just for purposes of the record, I would move for admission of defense exhibit D, as in David.
No objection.
Exhibit D is admitted.
One of the things we saw on the video is, I believe, before you make physical contact with Mr. Davis by grabbing his arm, you took, it looked like bags that were next to him. Is that correct? What were you doing at that point?
His property away from him. Unknown what was inside, could have been had anything in it. And then his altered state, he did want to positive.
Okay. And in this particular case, you did draft a police report, correct? So essentially, that is a detailed recollection of the things that you felt were important about this situation. Prior to making contact with Mr. Davis, did you have any awareness of the effects that inhaling nitrous oxide could have on a person? And what was that awareness?
Sometimes when someone's under the influence, or it can be aggressive and unpredictable.
And so you had that knowledge leading up to your interaction with Mr. Davis, correct? You saw him huff from this nitrous oxide bottle. And then it looks like while he's sort of in the middle of, for lack of a better word, being impaired by this, you and Officer Gonzalez are making physical contact and trying to get him to stand up so you can arrest him. Wouldn't you have had the option to simply wait and maintain some distance, before you did anything physical with him, given the fact that he's alone in this area where there's nobody else? Wasn't that a reasonable option?
It's not an option.
Because prior to making physical contact with him, he was just sitting. He was maybe saying things that were,
Sitting and committing a criminal offense.
well, I guess that's yet to be determined.
No, because if the inhalation of a chemical agent is a criminal offense in Michigan.
Well, I guess that's the question. Is it a chemical agent? And proposed exhibit number E, that's the last.
You referred to it yourself as nitrous oxide.
Yes, Your Honor.
Do you know the statute?
Well, the criminal charge that was charged against Mr.
Doesn't matter whether it
Was
was charged. It's the offense itself that the officer is viewing. The inhalation of a chemical agent for the purposes of euphoria, excitement, whatever, is a crime.
Well,
So if that's where we're going,
I guess
please get there quick.
I'll save that for argument then. If
Well-
I just may approach with the final exhibit.
Go ahead.
Thank you, Your Honor. Mr. Anderson, were you aware that the citation and the charge of possession of paraphernalia was ultimately dismissed in this court? Okay, that's okay. If you don't know, I would just move for admission of defense exhibit E. It's an official court order of this court, just for purposes of the record that according to the order, it's dismissed because the ordinance does not prohibit this conduct. And I believe it's admissible for purposes of the legality.
Ordinance doesn't. But still, for Pete's sake, any objection?
I would object to relevance, but I think the court could take judicial notice of it since it's from this morning and easily accessible with court's information, but.
And that's all I'm at.
I don't know what it's gonna matter, but what the heck, we'll just admit it. You do understand that state law is different than an ordinance? And that a determination under that was made that it did fit the ordinance. That doesn't mean that there wasn't a crime. You do understand that, Mr.
I understand the distinction, but I would also argue that inhaling nitrous oxide is not a violation of state law.
Really? I can't wait to hear that. All right, go ahead.
All right, thank you, Your Honor. Officer Anderson, would you agree with me that prior to making physical contact with Mr. Davis, he was sitting stationary, doing his own thing? In other words, he wasn't getting physically aggressive or combative toward you or Officer Gonzalez until either one or both of you attempted to make physical or did make physical contact with him, correct? All right. And at one point in the video, we hear Mr. Davis say, "No, I'm not going with you." Remember hearing that? And that would have been an expression where he's essentially saying, "Leave me alone. I'm going to stay here." Yes? Was there, when you heard the things Mr. Davis said that nobody would like to hear, was there any attempt by you or Officer Gonzalez to engage in further conversation or de-escalate the situation so it didn't get physical?
Not at that time.
Did either you or Officer Gonzalez, before making physical contact with him, identify yourselves as police officers?
Not verbally.
Did you or Officer Gonzalez, before making physical contact, simply ask him to leave on his own accord, get out of this area?
Because he was breaking the law, so we were gonna take.
When you saw that Mr. Davis was, had huffed, and as we said, for lack of a better word, under the influence of this, had you or Officer Gonzalez radioed for HVA paramedics? And was there any, I'm sorry.
Officer Gonzalez.
Okay. And so you knew they were on their way. And would you not have been able to simply maintain a controlled situation to allow them to come in and do a medical check before you made physical contact with Mr. Davis?
You can inject speculation. Don't know what.
Sustained.
Final few questions, Your Honor.
Let's hope.
When we see Mr. Davis get up from the wall after you and Officer Gonzalez made contact with him, did it not appear to you that he was attempting to walk between the two of you before it appears that Officer Gonzalez pulled out a taser on him?
Yeah.
Okay, was there a space between you and Officer Gonzalez that he could have walked through? Would you have allowed him to walk through? Okay. After Mr. Davis was tased, and we saw in the video, he's on his back, you tell him to roll over, takes him a few seconds, but he does so, correct? Tell him to put his arms behind his back. Once he takes a couple seconds, he does that, correct? And as you testified, he was cooperative after that point and onward.
It's verbally argumentative, but yes.
Not physically resisting. Okay. And your, again, actually, I'll withdraw that question. No further questions, Your Honor.
Any redirect?
Have two questions. Officer, how many different markings are on your uniform that identify you as police?
Five.
And
Back. That big silver thing in the front. Yeah, got it.
was Officer Gonzalez wearing the same uniform as you're currently wearing? Nothing further, thank you.
Had a big badge. Yeah, okay, just checking. Anything else?
Nothing.
Officer, you may step down. Thank you.
People have no further witnesses.
Defense has no witnesses, just argument.
People move for bind over on the information. I believe it's just a single count of resisting and obstructing. Court heard testimony and saw the video of this incident where the officers were attempting to apprehend and arrest the defendant for violating MCL 752.27. That being the inhalation or consumption of chemical agents, including nitrous oxide. I believe that arrest or that attempted arrest was lawful, and the court saw the defendant lunge at Officer Gonzalez during the commission of those duties. Certainly, he knew that these were police officers based off of the numerous markings indicating that they were police officers. He knew that the amount of force they used was reasonable, especially when the court again saw the initial attempts at just standing him up gently, getting him on his feet, and then he became aggressive. I would ask the court bind over on the information.
And so that you can frame your argument, I think that it's appropriate that actually there be two counts of resisting and obstructing, but go ahead.
Your Honor, under the resisting and obstructing statute, one of the elements that the Supreme Court has recognized is also an element for purposes of bind over is that the police officer gave the defendant lawful command, making a lawful arrest, otherwise performing a lawful act. And in various statutes, it talks about if a misdemeanor offense which has a punishment of more than 92 days incarceration, then a person can be arrested for that by statute. That's 76415. The case law, and I'll get to the chemical agent, but my argument essentially, Your Honor, is nitrous oxide is not a chemical agent. But the first part of that is
Where does that come from?
752271. And there's two areas.
Does it specifically delineate that nitrous oxide is not a chemical agent?
It does not, but by its description, the definition of chemical agent, 752.271, as used in this act, the act is what prohibits, for the purpose of causing a condition of intoxication, intentionally smelling or inhaling the fumes of any chemical agent. And it's defined as any substance containing a toxic chemical or organic solvent or both, having the property of releasing toxic vapors. Term includes, but is not limited to, glue, acetone, toluene, carbon tetrachloride, hydrocarbons, hydrocarbon derivatives. Nitrous oxide is not included. I understand, though, it's the statement is includes but not limited to. But nitrous oxide is not a chemical agent because it does not contain a toxic chemical or organic solvent. And if I could,
You realize nitrous oxide is toxic to humans?
it's used at dentist offices. It's not toxic to humans. It's a compound, but it's not a chemical agent as defined by the statute. And I think the fact that another part of that same section, 752.272A, prohibits people from selling. Here's the statute. Part 1, persons shall not sell or distribute a device that solely contains nitrous oxide to a person under the age of 18 for any purpose. It prohibits people from selling these things to minors. But nowhere in the statute does, when this statute specifically is directed at nitrous oxide, nowhere does it prohibit the adult use of nitrous oxide. And so when a statute directly addresses something like this particular substance, but does not prohibit the use or possession by adults, then I believe the statutory
So
can't.
what do we do with dust off?
What do we, I'm sorry.
Yeah, I mean, as an adult, I can go in and I can buy dust off all day and night long, to the extent I can find it,
Yeah, it's not.
but not a minor.
That's what the statutes are focused on. And I think because there is no statute that prohibits the use or possession of nitrous oxide by an adult, then
It's the chemical agent. It is not, go ahead.
it's presumably legal, especially when there is a statute that is directly focused on the sale and distribution of nitrous oxide as illegal to minors. But why wouldn't it mention anything about the possession or use by adults? Because it's not a chemical agent under the.
No.
That's my argument, Your Honor.
Yeah, I hear it. I don't know that that's an argument, but that your logic is incredible to me.
Well, let me just finalize this by saying the reason the two officers arrested, as was testified to, Mr. Davis, they wanted to stand him up and arrest him for possession of drug paraphernalia. He was cited for that. That was dismissed. That's in the court record. And the dismissal order indicates because it's not illegal.
So, Mr. Farfelsky, let me ask you a question. Let's presume in one of the 9th rounds that you're correct regarding nitrous oxide. When the officers come to investigate, ask him to stand up, are asking to identify and just investigate what they may perceive as a crime. And I think the case law is rather clear. When they're investigating, even if incorrect, that doesn't make the command or what they ask unlawful. So at that point, while they're investigating, are you indicating to this court that the offense of, first of all, grabbing Officer Gonzalez, again, not complying with Officer Anderson, and then charging at Officer Gonzalez doesn't fall under the statute of resisting and obstructing?
Well, Your Honor, the case law on this element of.
Are you arguing that?
I'm arguing that because this element of resisting also implicates Fourth Amendment search and seizures issues, and that's straight out of People versus Morosky, 2023 case. If the
officer is briefly detaining someone to investigate the potential of a crime, gets charged at, are you saying it doesn't fall under this statute? Yes or no?
Yes, because the police precipitated a situation that did not have to occur. That prior to getting the police officers getting physical, making physical contact with Mr. Davis, he was minding his own business. And it wasn't until they laid hands on him, tried to physically seize his person, detain him, and then pull out tasers, that I would argue he had the right to resist an unlawful arrest, because at that point.
He had the right to charge as that Pittsfield officer. Is that what you're telling me?
I'm not saying that. But
is that what you're telling me?
Protect himself from a taser.
Please finish your argument.
That's it, Your Honor. I would object to bind over for those reasons.
Anything from the people?
I believe the court has the power of the court to add charges if it seems fit. If the court wants to bind over on additional charges, the people have no objection to that.
Court has listened to the testimony in this case of Officer Anderson. Officer Anderson is called or is dispatched to the location as a result of a citizen's complaint. You can hear the individual say what is going on. The officer goes over, sees that. I do not believe by any stretch of the imagination under the circumstances of that use of nitrous oxide that does not fall under the statute of 752.272. He's inhaling it. You can actually see him on the video inhaling it. The officer tells him to stop. The officer, even if at that point, if the officer is incorrect as to what it is, while the officer is investigating that, the officer is giving a lawful command so that he can fulfill his obligation to investigate what's going on. Officer Gonzalez arrives. What is then further clear is that they get him up. He then charges at Officer Gonzalez. They have to take him down and they have to tase him. I don't know under what argument that the defense says it's okay while an officer is even just minimally investigating the potential of a crime, that officer could be charged at and physical contact made with that officer. If you show me some case law that indicates that, then I won't bind over. But you don't have it because that's not the law. Plain and simple. People have indeed sustained their burden of showing that the defendant has committed the offense of resisting and obstructing police officer and first responder on count one, that being as to the resisting and obstructing as to Officer Gonzalez, the 2-year felony. The court is going to add an additional charge of resisting and obstructing a first responder for his conduct as it relates also to Officer Anderson, as the court believes that all of the commands that are given by Officer Anderson while initially going there, and then as he is further giving commands to him at the time that after I'm plain spoken, at the time that he attacked Officer Gonzalez, all of those lawful commands he did not abide by at all and did not comply with. And so the court believes that an added count 2 of assaulting and obstructing a first responder police officer is proper. The defendant is bound over to stand trial on counts 1 as pled and count 2.
Your Honor, as to arraignment, waive formal reading and stand mute to both charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for
August 6th, with Judge Slay.
We may have to arrange that date. As to bond in this case, I'm gonna be honest with you. I do not. This person poses a risk to the public. I see a lot of resisting and obstructing cases. It is rare, very rare, that as the officers engage with the person, that you see somebody charge an officer and then not comply to the point that these officers then have to deploy their tasers. And had they not, quite frankly, as he's coming at Officer Gonzalez, I don't believe he would have stopped. So you tell me why this person isn't a danger to the public, and I don't know why he has a PR, quite frankly.
Your Honor, I don't believe my client has any prior convictions. I know that he is in close contact and supported by his family. I've spoken to his mother. While he's been on the current bond, he's had no issues whatsoever at all, always appearing. I believe he's testing at community corrections, and I don't believe there's been any issues. So I don't see that there's anything that has changed given the fact that he's been absolutely compliant with the court's bond orders.
If there's anything from the people, I really don't need it, but
I would note that the people's original request did not include a monetary component. The original request was just for a conditional release, that being with some alcohol and substance abuse testing. I know that he doesn't have any prior criminal history. Ultimately, based on what the court heard today, if the court thinks that a monetary component is appropriate, I'm not going to object to that, but I will leave it ultimately to the court's discretion.
anything else?
As far as that, Your Honor, my client, I believe, works at a coffee shop. Or doesn't currently have a job. He was terminated a couple of days ago, but he wasn't making much money. He doesn't have much in the way of resources for a cash bond. And again, he's been absolutely compliant. There's been no safety issues in the community or with this court or anybody else.
If you run at an officer in the fashion that he did, he is a risk to the public. Bond is setting him out of $15,000 cash surety. Defendant is remanded. Give me an in custody date. Pardon? The date is still the same. August what? August 6, 2026. 9 a.m. before Judge Slay. Can you approach?
Can you please?
What? Holly comes out.
No.
Fall off. Court does call the case People versus Chance Baylor.
Alexander, on behalf of people, Your Honor.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Baylor, who is approaching.
Take your hands out of your pockets, please.
Would you please state your name, sir?
Chance Baylor.
And Your Honor, today's the date for the preliminary examination. At this time, the people are unable to proceed, we ask the court to remand down on count 2. And I did make an offer to Ms. Gaines for domestic violence with sentencing of 4 a.m. for the first one.
For the first picture. All right. You're moving to dismiss count 1, Ms. Gaines.
Yes, Your Honor.
All right. Count 1 is dismissed. I'll continue as not guilty plea as to count 2. I'll set this matter for a pretrial,
June 29th at 1 p.m.
June 29th, 2026, 1 p.m. That's before me. Bond with its conditions will continue.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls case first.
As and on behalf of the people, Your Honor.
And Assistant Public Defender been done with on behalf of Mr. Cotton Robertson, who stands to my right. Sir, would you please state your name for the record?
Castellian Ramon Cotton Robertson.
Thank you. Your waivers.
That's correct, Your Honor. The defendant will be waiving. There is an offer for the defendant to waive up and plead to count 1 in case ending in 1342 with HIDA, and then plead to count 2 in case 1725 with sentencing under 1794A.
And the count 1 would be dismissed on the second case, correct?
Correct.
Thank you.
All right. So you're waiving your right to preliminary examination? And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Sure.
Yes?
Yes.
All right. People also waive their right. Defendant. Preliminary examination has been waived. Defendant is bound over to circuit court on count 1 in both cases, with count 2 following in the case ending in 1625.
Stand mute, waive the formal reading, both cases.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 12th at 1:30 with Judge Conlon.
August 12th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond with it will continue. Thank you. Yes, sir. Yes, ma'am. 1 month. What's that? I have the wrong glasses this morning. Yes, it is. Thank you. Well, we got a problem. I've got that one. I have that information in that one. This one. I know. Joe, take it. Court calls case People versus Lamar, Hampton.
Your Honor, bring both the people.
Good morning, Judge Wade Fink on behalf of Lamar Hampton, who's present and standing to my right. Mr. Hampton, could you state your name?
Lamar Hampton.
Thank you. He's waiving.
Yes, Your Honor. We are prepared to waive our right to preliminary exam, and I have the form here if I could hand it to the bailiff.
Sir, you're waiving your right?
Yes, sir.
You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
Will also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, as to the arraignment, we ask that we waive formal reading and would ask the court to enter a not guilty plea.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty pleas. Pretrial will be set for
August 6th at 1:30 with Judge Slay.
August 6, 2026, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond continued with its conditions.
Thank you.
The information.
Yes. Thank you. I do. Court calls the case of People versus Ter Shivers.
Morning, Your Honor. Agreement.
Public Defender Ben Dunn on behalf of Ms. Shivers, who stands to my right. Miss, would you state your name for the record?
Ter Shivers.
You take the answer.
Your Honor, this is the day and time set for a preliminary examination. At this time, the people are unable.
The defense would ask for a dismissal.
People being unable to proceed, this case is dismissed on defendant's motion.
Thank you, Judge.
Thank you. Court calls case People versus Travis Terrell McDaniel.
Morning, Your Honor. Katie Rusmersky for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. McDaniel. Mr. McDaniel, can you please say your name?
Travis Terrell McDaniel.
All right. He's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 and 4 following. Mr. Bernstein.
You're going to ask the court to please waive any further reading, enter not guilty plea, and ask for a circuit court date.
Defendant having waived formal reading, pleading not guilty as to all 4 counts, court will enter that's not guilty pleas. Pre-trial in this matter will be set
August 11th at 1:30 with Judge Hampton.
August 11th, 2026, 1:30.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Judge.
You can have Mr. Leslie sign that information. Court calls case of the People versus Kenneth Tucker.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Jay Bellinger on behalf of, but unfortunately not with Mr. Tucker, Your Honor. The most compelling argument that I can make for his absence is not one that I can provide today. I will state that he provides that he is on his way. He's a couple hours away. He just had transportation issues as I talked to him yesterday. My understanding in talking with Mr. Cook today is that the people aren't unable to proceed and prepared to dismiss. I don't know what that does for you, though.
That is correct.
Oh, none of this does anything for me. I don't know what that does for you.
Well, personally, it doesn't affect me as much as it affects my client potentially.
It is correct that the people are unable to proceed. I leave it to the court's discretion how the court wishes to head with this.
So is he on his way?
Couple hours out, Your Honor, but yes, according to him, he is on his way. And I don't have any bus pictures to prove it or anything like that.
He's a couple hours out from Belleville?
Your Honor, as I spoke to him yesterday, he was visiting family, so he's not in Belleville. He is in the state of Michigan. That's all I'm advised.
Because you don't want a bond violation, but.
Well, I'm.
No.
What I don't know can't hurt me. We're hoping, Your Honor, for a dismissal without prejudice in this case. We're very hopeful.
Except he's got to be here.
Does he?
Yeah. Bench warrant will issue for the defendant's failure to appear. I'll do it this way. Bond will be set in about $25,000 cash as surety because he didn't show up at his preliminary examination. I will not issue that warrant until June 22nd. So get him in here, get him. Okay, thank you.
Thank you. Have a great day, Your Honor.
You do the same. Court calls the case of the People versus Philip Deicricio.
Katie Rusmersky for the people.
Good morning, Judge Lawrence H. Margolis with and on behalf of the defendant, Mr. Deicricio. Philip, please state your name for the court.
Morning, Philip Deicricio.
Is this going to be a guilty plea?
Correct.
So I have before me a form that indicates that the defendant will plead guilty to stalking domestic relationship account 2, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement of 5 years probation and any jail term, or I don't know what that word is. Jail term is up to the sentencing judge. Yeah, any. No, it's okay. All right, that's the court's full understanding of this.
That's correct.
And that's it.
All right, may I have him sworn?
I swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. State your name and spell it for the record.
Philip Deicricio, PhilipPatrizio.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of stalking with the domestic relationship tag. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, plus court costs and up to 5 years probation. You understand that, sir?
Yes, I do.
Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
All right. Do you still wish to plead guilty?
Yes.
All right. And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form. Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that.
Yes, I do.
You understand you're giving up your right to equal upright. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you? Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will? And because you believe that you're guilty of this offense? March 15, 2026, at the location of 2490 Dungara Drive, apartment 512, City of Dexter, Washtenaw County, State of Michigan. What did you do with reference to a Jennifer Deicricio that makes you think that you're guilty?
I sent her emails when I wasn't supposed to.
You continued to send her emails?
I communicated with her via emails.
And she had told you not to, or there was some order in effect,
Correct.
which told you not to communicate or have any contact. Is that correct?
Correct.
And these emails you sent, you did that intentionally?
Yes.
All right. Sir, I do have to advise you that if between the time of the acceptance of my plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, court would no longer be bound by any sentence evaluation or recommendation. You understand that? And you would not be entitled to withdraw your plea.
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
There are.
No, Judge.
And have I complied with the court?
Court has.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be July 16th, 2026, 1 p.m. Judge Freshour.
Judge, may we be heard on bond? I'm seeking to have your honor authorize removal of his tether. He's had a tether on since March 22nd. There's been no violations. He has no criminal history. He lives in Canton, far away.
I can just stop your argument. I'm not going to release him from the tether. I'm going to let their probation department look at him, and then they can make that.
Understood. Thank you, Judge.
All right. Bond will continue. Thank you.
Thank you.
We were on a roll. How many more do you have?
Yes.
This is correct. The court does call the case People versus Aaron Brandon.
And then on behalf of
Thank you, Your Honor. Alex Warren Green on behalf of
Aaron Brandon.
And you received the 8 times separate preliminary examination. At this time, you are unable to proceed as to counts 1, 2, and 3 with S and court remaining on count. District Court.
The defense would move to dismiss with respect to counts 1 through 3, Your Honor.
Court will dismiss counts 1, 2, and 3. I'll continue the defendant's not guilty plea as to count 4. I'll set a pretrial
July 13th at 9 a.m.
July 13th, 2026, 9 a.m. before Judge Washington. Bond will continue with its conditions.
Your Honor, may I briefly address condition of bond?
Sure.
Thank you, Your Honor. Your Honor, Mr. Brandon is currently on home confinement. He's asking the court to consider either removing that tether or converting his bond to allow for a hot zone tether to complainant's address, which I pull on. I think Mr. Brandon has been on tether for a total of 4 months. 2 months ago, it was modified from hot zone to home confinement. During that period of time, Mr. Brandon tells me there's.
Why was it modified?
Your Honor, I believe that happened at the time this case was charged. He had another case that was dismissed a couple weeks ago that he was on a hot zone tether for, and this is my understanding. I defer to the people if they have a different version of events, but
your understanding is he had another case. He was on a tether on that case. This case then happens. That tether, the tether is then applicable to both cases, but now becomes a home confinement.
That's correct, Your Honor.
Yes.
Case pending before Your Honor for another domestic violence case, different victim that occurred on 11/8. This case, which I discovered as I was preparing that case that was in our queue, happened on 1/15/26, was a different domestic violence case involving the use of a weapon with a different victim. And at that time of arraignment of the new case that we're here for today, Your Honor, we changed the bond for the tether to be home confinement, given that it was a domestic violence.
And that's what I thought I called him. Anything else?
nothing further at this time, Your Honor.
I'm not going to change the bond. It's going to issue the confinement will be the same, and then I'll let Judge Washington deal with how she's going to handle that. Right?
Thank you, Your Honor.
Text you. Is this new?
I don't believe so, no.
That came at the, I got it around today.
Yeah, but it's not a new violation. I believe you've reviewed it.
Right, I've seen it, but we didn't deal with it. Who's on this one?
Mr. Warren Green and just stating this over. Any, I'll step in for you and any.
Are you ready, or you want me to, you need more time? What are you doing?
Your Honor.
What, so that's a no, not, because you started with something else.
Can read my mind. I would just ask for a moment. We were reviewing the people's offers and.
Oh, okay, that's fine. I'll step off and you guys let my staff know when you're ready, and I'll deal with the court.
Your Honor, I appreciate the accommodation.
All right. For you, anything.
What started as a simple court hearing quickly turned into one of the most dramatic moments of the day. A woman had come to court seeking an expungement, and the judge was actually prepared to grant her request. There was just one problem. She hadn't completed the required paperwork. The judge explained that she needed to submit a proper order before the court could move forward. But instead of listening, the woman continued arguing. The judge repeatedly told her that it wasn't the court's job to fill out paperwork for her. If she chose to represent herself, she needed to follow the instructions and complete the process correctly. Yet the interruptions continued, and the tension inside the courtroom quickly escalated. Then came the moment nobody expected. The judge finally lost patience and ordered her to leave the courtroom. "Get out of my courtroom!" But the woman kept talking. That's when the judge delivered a warning that instantly silenced the room. "One more word,